and I just turned on the recording button. So the proceedings will be recorded, and I'm hoping that this will still allow us to have an open and honest dialogue. I'll now turn this over to my dear friend and former colleague, Darlene Johnston, for the first panel.
Thank you, David. Welcome, everybody. I'd like to acknowledge before I get started that I'm participating from the traditional, ancestral, unceded lands of the Musqueam people. I'd also like to acknowledge that the Musqueam people are in mourning for the loss of Ronald Bud Sparrow. You may know him by the case that bears his name, the Sparrow decision, where he fought to defend his Aboriginal fishing rights all the way to the Supreme Court of Canada. For myself, I'm an associate professor here at the University of British Columbia, the Allard School of Law. My people come from Ontario, though. I'm a member of the Chippewas of Nawash First Nation, and I belong to the Martin clan. I'm delighted to introduce our first speaker on this panel. It's Darcy Lindberg, who's an assistant professor with Alberta's Faculty of Law, where he teaches courses on constitutional law, Indigenous legal orders, treaties, Indigenous environmental laws. He is mixed-rooted Plains Cree, with his relations coming from Sansom Cree Nation in Alberta and the Battleford area in Saskatchewan. His research focuses on the constitutional and legal theory of Plains Cree peoples in relation to lands, waters, and animals. So welcome, Darcy.
Thank you. Thank you for that great introduction. And I just want to make sure my audio is good. So if I can get yeah, thank you, Darlene. So really grateful to be here, to be invited into this virtual space at a last minute. I do have to send my regrets, as the rest of my panel knows. Actually, I'm teaching a course in a half hour, so I'm in the law center we have here right now, and I have to scurry away, and then I'll come back and join the later discussion. So my apologies for that. But in the time that I had, I actually was thinking, what could I, knowing that I would be first up, what could I introduce to this event? And I just want to share one sort of approach that I have towards constitutional law. This is actually my first term teaching it, but I've taught this in other courses as well, is really using treaties as an approach to decolonize law generally, but constitutional law specifically. And so I just want to talk a little about that. So I'm actually going to share screen if I can do that. Oh, I can't do that. So I'm just going to walk through this here. Why I find treaties really important for an avenue towards a decolonial look at constitutional law. The first is it introduces and provides an avenue towards Indigenous legal orders. So I know Professor Mills and Professor Hewitt are going to talk about that as well. And so it'll kind of lead into, I know some of the other speakers this afternoon will as well. The second part is that it is often a meeting point. Treaties are often a meeting point for Indigenous constitutions and Canadian constitutionalism. So for example, from the Plains Cree perspective, we couldn't talk about how we constitute ourselves as peoples together on the land without talking about treaties. So we actually have a term, Wetaskiwin, which is where I actually grew up. It's a town here in Alberta. And that's actually a Plains Cree perspective, a legal foundation for treaties. So I actually talk about that quite a bit in all of my classes. It's one of these foundational things. And third, yes, sorry.
Sorry to interrupt you. I think I've allowed you now to share if you'd like.
Oh, awesome. Thank you.
Okay.
And the third one is it really just broadens the constitutive narrative that we have. So, so I'm going to share the screen here, and you can check out my hastily put together PowerPoint. We're going to go from current slide. Okay. So how I do this in this course is there's two sort of pedagogical methods that I use. There's other ones as well, but these are the two I want to highlight here. The first is I personalize treaties for our students. And so I send them off with a research project that really focuses on individual and their familiar exploration of treaties. And then the second one is I really retextualize Treaty 6 from a Plains Cree perspective. And part of that is looking at exploration of treaty spaces. So really lucky on campus here to have right out the door places that we can talk about treaty, and then try to introduce experiences and legal processes that are actually fundamental to treaty for Plains Cree peoples. So the personal treaty project, this is very simple. I send students away with a sample of questions that they have to come back and present on. So here is a list of them. One is, how am I a treaty person? What benefits has treaty provided to me? What are my responsibilities because of this relationship? Did you grow up on treaty lands? What's your family relationship? Also, I acknowledge that we have law schools and law students who are coming from lands where treaties haven't been negotiated between Indigenous peoples and the Canadian state. And that actually provides a really beautiful opportunity to talk about that other particular context and how the voids in our sort of constitutionalism, the way Canada will hold up its constitution, but being void of these agreements. So we have all these really great conversations that flow from this. So these are sample questions. You can reword them as you want. You can do what you wish. What this leads to is just a really great reflections on what treaty means. And so this is my own reflections on this project. The first one is that we have really differentiated responses, obviously, to these questions. So we have Indigenous students, generational non-Indigenous students. And what I mean by that is people who are non-Indigenous, but they've been in a treaty area for, let's say, 5 or 6 generations. We also have families that have recently immigrated to Canada who are working through those. We have non-treaty land questions, etc.
Excuse me, Darcy,
yes.
Sorry. Your slides aren't advancing. We're still on why exploring treaties in this way is important.
Okay, I'm gonna stop the video. Oh, maybe it was, I see what happened. Is it working now?
We're still on the same slide.
Yeah, okay. Yeah, I got a message here that says, I'm just gonna stop share. And then I will just continue talking because it's just more important that I use this time because I actually do have to run away here pretty quickly. So as I was saying, one of the really great learnings that has come from this is students who've come from areas where there isn't a treaty yet. So we've had students from Musqueam and Tsleil-Tooth, and they'll discuss this with people who've recently immigrated to Canada as well. And they've been really able to share this, and I think change, for the most part at the University of Alberta, we get students who are from the prairies and mostly Alberta. And this other narrative comes in and it changes the perceptions of students as well. So it's a really full experience in that sort of way. So I found it is really important that I supported the students by having a pedagogy that really talked about storying as a valid part of the law school experience. So the personal experience of our students is really important, and they're able to share this, and it's not just something that is outside of our legal dealings, because actually within a Plains Cree tradition, we talk about this being as a really important part of law. The second one is really to facilitate the connections between personal stories and the case law. So really in my treaties course, we talk about all the Supreme Court case law, and we delve into Treaty 6 case law quite a bit, and really tying these experiences of students into there. And then the third part is just recognizing that treaty stories are a part of the ethical obligations of practicing law. And I think about that from 2 perspectives. The first is as legal practitioners, for example, let's say with the Law Society of Alberta, there is the calls to action to learn these stories and to consider this. And the second one is from a Plains Cree perspective of what it means to be having legal obligations together as well. So those are really important. So the second part I want to talk about really briefly is visiting treaty spaces. So I'm actually doing that with my students today. That's why I can't stay with you longer. So I'm going to run out here and around the University of Alberta. We have specific spaces that either memorialize Treaty 6 specifically, or talk about, or are actually a place of meeting of Indigenous peoples to this territory for quite a long time. So I walk our students, we just walk around and we talk about treaty in there. It's a really good event as well. It reveals a lot of the racial and colonial underpinnings of treaty recognition as well. So here on campus, we have certain art pieces that memorialize treaty that were done in the 60s. And what it is, I'm gonna try to pull one up here. I know I'm having trouble sharing screen, but it's mostly why I wanted to do the slideshow, is just to show this. So we'll try this again. So do you see the picture, Darlene? Yes, okay. So this is a painting that's in the Rutherford Library here, and it's depicting Treaty 6, the signing of it. And I like to take our students here to look at this. This is obviously a very romantic vision of treaty from a European perspective. And just to contemplate what they're seeing here. So you can see we have these, loincloth dressed, I assume they're Cree people who are very physically healthy, but nothing else. So we talk about this, and I tie this with the case law. So we all know the Silly Boy case from Atlantic, Canada, that is really racist in what they decide there. And we talk about this changing view of treaties in Treaty 6. So I converse this with, we also have another really powerful image in the opposite here on campus. This is a Treaty 6 territorial marker. And what this is done by Stuart Steinhauer of Saddle Lake has carved this as a way of reflecting his family's, which is Plains Cree as well, vision of treaty. And so we walk around there and we talk about the symbolism that a lot of our Indigenous nations here in the area use for this. So this part of the picture you can see there is talking about the sun shining and the water flowing and the grass growing. And we talk about what that means, that symbolism actually means for a treaty as well. So that's a really important one as well. So when we do come back and we're dealing with these constitutional texts that deal with treaties, those two activities really center, personalize treaty for our students. And the response has been really quite remarkable and outstanding for somebody who's Treaty 6 and who knows these stories. So I just wanted to share this maybe in closing here. So this was one of our students. What they went through last year is they actually decided they're going to do a research paper on the treaty bear. And so they contacted the carver, Stuart Steinhauer, and they had this wonderful dialogue infused with our laws. So there's protocols involved. I won't get into here. But this is something that Stuart had told our students, that foolishly, I thought I could fix the problem of genocide in Canada by thinking about it. And then obviously taking some generalizations here, Stuart says the Indigenous version of the treaty story goes in a different direction. So really, I took this out as like, this is calling us to action. And with our methods, Plains Cree methods, I talk about that. It really is, the law is how we're acting upon it. So, so I just wanted to share that with you. I also think about this process of personalizing treaty for students. We never would have received this knowledge from Stuart if we didn't embark on that journey there. Okay. So I kind of ran through that pretty quick. I do know we wanted to leave a little bit of time for questions before I got off here. So I just hopeful that was a fruitful opening to this symposium. And I see a lot of familiar faces that I'm really excited to learn about as well. So I'll turn it back over to Darlene.
Thank you, Darcy. Could you stop sharing your
Yes,
screen now?
yes.
Okay, that's great. Thank you so much. So we're open now for questions. Darcy has about 10 minutes to spend with us. If you go to the participants panel at the icon at the bottom of your screen and open it, you can raise your hand by pressing the blue hand icon, which says raise hand, and then I'll be able to moderate the questions. It's also possible, if you're more comfortable with using the chat function, I'll also moderate that for people asking questions. I'm not seeing any blue hands. I'm wondering, is there, do I need to be a co-host to see the blue hands if Emma's still with us?
I don't see any blue hands just yet. But
David, do you see anything, like any hands?
no, nope.
Hmm.
You?
No, I don't see anything either.
Okay, well,
Great.
Maybe nobody has any questions.
No questions. I just
No
explained it
questions.
perfectly.
so Darcy, maybe I'll ask something just to
Yes.
kick things off. Um, uh, so how does one do this? What you're doing, introducing treaty and taking people to locales. Um, uh, how does one do this in a course where you're expected to talk about other constitutional moments and other constitutional documents? So how does this get wrapped up into discussions about Royal Proclamation, Quebec Act, 1867 Act? Um, does this precede all of that discussion?
Yeah.
Is it anterior or after the fact? So how might one think about sequencing all of this?
Yeah. So that's a really great question, David. I would say, I mean, with the idea of visiting spots on campus, it's not new. I think a lot of universities do this. And generally what it occurs is before classes start or some sort of broad, I know at the University of Victoria as well, they do this, where it's all the students are meeting on specific sites of territory there. How I've chosen to do it in my treaty course is actually I do introduce the Royal Proclamation and the Treaty of Niagara first. So we talk about this vision that was at that moment of time of we're having nation-to-nation agreements, and I talk about the some of the work that Aaron has done with like even just referencing wampum belts and those sorts of things as well, and then. We talk about, so that's a nice lead in here specifically, because then we see where that sort of view of treaty has changed, and then it's recovered through the sites here on campus as well. So for an example, my readings for my treaty course this week were the Royal Proclamation and John Burroughs's Canada's Colonial Constitution in The Right Relationship, that book. And that was to give them that sort of 140 years that John talks about of treaty mismanagement and its interpretation, and see where we're going as well. So to answer your question, for me, I find it really effective that we're introducing case law and text before that. So they're going out there and they'll have that kind of reference they're dropped into to have that, I don't want to use the word, the angles of the jurisprudence to think about how, the colonial underpinnings. The other thing that I do as well is I assign Harold Johnson's Two Families book, even when we're doing case law. So like next week, we're going to talk about various cases about interpretation. And then conversely, they're reading chapters of Harold Johnson's book, where he's talking very specifically from a Bush Cree, a Woodland Cree perspective on Treaty 6 as well, to give that again, that refraction that they can start to think, okay, there's a decolonial view here, and how do we look at the case law in this?
Thank you.
Yeah.
I'm just going to try raising my hand to see if it shows up.
Oh, I see one. I see an actual hand raising.
All right, that's great. Thank you. Professor Kirsten Anker, would you please ask your question?
Hi, Darcy. I'm Kirsten. I'm at McGill University with Aaron. And just want to say that I'm using your text, Beautiful Creeness, in my course coming up soon.
Oh.
So I've been also toying with doing a similar assignment, getting students to kind of place themselves and think about different stories about where they live or where they might be attached to. And I just wondered, have students been able to find information easily enough? Because some of the histories are well recorded and in the public domain, and some of them are not. So have you encountered issues around that?
Yeah, so that's a great question. I let students know that it's going to be really varied. So some students, especially we're talking about Treaty 6 already generally, and if they're from Treaty 6, they're going to be able to spring into conversations more easily, where other students, for example, the students we had who are from, Musqueam and Tsleil-Waututh territories, they come back and like, well, there's no treaty here. And then it was more dialogue with them about like how they can think about that that relationship of treatylessness. So really, in terms of like a pedagogy, really being really open with evaluations. I didn't say you have to hit these points and you're going to get marks for those. Every person was going to be different. A lot of people actually chose really just to look at their family, right? And so they're saying, we are treaty 7, and here's why my family has never talked about this, right? And so that's more so what I saw coming up. It wasn't the hardcore, like, this is actually what the treaty is. It was like the personal relationship, which was really the heart of what I really wanted out of that. Yeah.
We have a question from Sonia Lawrence. Sonia?
Hi, everyone, and hi, Darcy. Thanks so much for this really interesting talk. I hope you guys can hear me. My question is about actually doing this in the classroom, and I'm just wondering whether you have had experience of students saying things or contributing things that are highly problematic in the context of either they're racist or shading towards that. And I'm wondering how you deal with that both before and after in the particular context of treaties, where you will definitely have Indigenous and non-Indigenous students in your class.
Yeah, that's a great question. And I think that might be a theme throughout the day, because I know there's a lot of experience around the Zoom table here in dealing with that. So for these classes, I haven't dealt that in a first year constitutional law class. This is my first go around with it. So in the courses that I have been teaching that have had Indigenous focus, that's been mostly obviously self-selecting students in there. But that still comes up, right? Especially in our treaty course, these kind of outdated views of treaty still come up. And I mean, it's a pedagogical choice. It's a seminar class where we talk about those. So every time there was something that did come up, somebody would say something that was off color or frankly just wrong. One, it was the environment right from the start. Another thing I like to do in that class is we'd check in every week as well. So there was this trust already built there that when there was contentious conversations, I found that the students around the table would just jump in and were fairly diplomatic. So I know that's kind of, you know, pie in the sky. That's the best case scenario. But I do think that for me, it's always just giving more information, right? So I like to always point back to that quote by, I think it's Thomas King, where he says, you know, you can do what you want with these stories, but don't forget that you've heard them, right? And that's my kind of theory with people who are speaking up who are racist, is really just to continue to feed them with that information. And eventually it changes. So I know that doesn't do anything about like the harm for everybody else that occurs there as well. There's a lot more work that you need to do when we have, you know, people are speaking racistly in class and being overt in how you shut it down and those things. So there's just very basic strategies in that. But that's one that I've shared. And I do think that is a conversation that other people can bring out how they've dealt with that in the past as well.
Darcy, we have one more question, but I'm noticing the time.
Okay, well, I'm meeting my students like 50 feet away here. So I might close up and run out really quick. So we'll take the question here.
Okay, Vanessa McDonnell.
Thanks. Hi, Darcy. Hi, everyone. So I have a question about how we think about teaching in relation to land in a moment where we're all on Zoom. And, you know, on the one hand, because our students are everywhere, maybe there are possibilities for thinking about land in ways that there weren't when we were all in one physical place. But on the other hand, there are maybe challenges. So I'm wondering if you have thoughts about how we can, you know, like thoughtfully make those connections between law and land in this strange online environment.
Yeah, so that's another really great question. So, I mean, I guess there's two ways. There's one is really looking at this as an opportunity for people, if your students are spread out across different territories, of really going out into the land and having these questions about, so we're gonna walk today, and one of the questions I'm gonna pose to my students is saying, how, from this Plains Cree perspective, does the land, why is the land important to treaty, right? So that's kind of like a pedagogy question that they're gonna experience walking on the land, and we're gonna talk about that. So setting up, questions like that where people can have self-reflection, I think that's a really good opportunity here as well. The other thing I'll share was something that that experience that a student had with Stuart Steinhauer, the carver of this bear. They were physically distanced. It actually occurred right when we all went to lockdown last spring. And so he wanted protocol. He wanted tobacco to answer. It was a tobacco question. And it was really nice. And it was actually really like, I just found it really endearing how, because they were including me in their emails, how they're setting it up, working out these protocols in the time of COVID, right? And he's like, oh, you can put the tobacco down there, and actually opened up a lot of really great teaching moments for the student and for me as well. So that's just to say that there's protocols from the territories or legal processes is probably a more broader way to say it, that they're adapting to this time as well, that we can engage in, and that can provide a lot of learning. Okay.
Well, thank you so much, Darcy.
Yes.
Really
Just want to
appreciate
say
it.
thank you for the opportunity. I feel bad I have to run, but I'll be grateful to jump back on here in a couple hours as well. So take care, everybody.
Thanks, Darcy.
Okay. So our next speaker on the panel, the two speakers actually are going to have a dialogue. So, and then we'll hopefully be able to get others to join in. So I think I'll introduce them at the same time, if that's all right. Well, maybe that's a bit confusing for people who don't know them personally. I'll start with Aaron. Aaron Mills has his JD from Toronto, an LLM from Yale, and a PhD from the University of Victoria. He's an Anishinaabe from Couchiching First Nation, Treaty 3 territory, and he belongs to the Bear Clan. He joined McGill as an assistant professor in 2018 and took up the Canada Research Chair in Indigenous Constitutionalism and Philosophy a year later. His work regards Indigenous conceptions of legality and the relationship between Indigenous and Canadian constitutional orders. Both his research program and his teaching responsibilities are guided by the teachings he has received from and his ongoing engagement with Indigenous community. Welcome, Aaron. And for Jeffrey Hewitt, Jeffrey is a mixed descent Cree and an assistant professor at Osgoode Hall Law School, York University. His research is mainly community-based, and his interests include Indigenous legal orders and governance, constitutional law, and visual legal studies. Jeff teaches and has taught constitutional law, Indigenous legal orders, access to justice, and Indigenous peoples' art and human rights. Professor Hewitt has delivered a number of guest lectures to a variety of audiences, including the judiciary and the legal profession. From 2002, Jeffrey served as General Counsel to the Chippewas of Rama First Nation, during which time General Counsel's office received a 2011 Canadian General Counsel Award for Social Responsibility for work with First Nations elders and youth. In 2019, Jeff was a recipient of the Law Society Medal from the Law Society of Ontario. Jeffrey holds an LLB and LLM from Osgoode Hall Law School and was called to the bar of the province of Ontario in 1998. Jeffrey is past president of the Indigenous Bar Association of Canada and served on various boards. He is currently on the executive of Legal Leaders for Diversity, as well as a director for the National Theatre School. And welcome to Jeffrey. So I understand Aaron's going to start the conversation.
Okay, bonjour, Ndinwe Moganidok. Hello, my dear relatives. Thank you for that introduction, Dar. It's really wonderful to be here today. I see many friends, many whom I haven't seen for quite some time. So I'm grateful to be in this space. And I'm grateful to David for his vision to create it, to bring us together. I've also been thinking that my gratitude to see so many folks present today who are interested and who care about taking up this difficult question. As a relatively new, my third year of teaching, Indigenous law professor, I really take heart to see so many people here for this today. And I wanted to begin in sharing that. I'm also grateful that Darcy offered such specific substantive recommendations because my approach is a little bit different. And as Darlene mentioned, Jeff and I discussed that I would sort of speak, not at length, but for a little bit at the outset, just to help set up the discussion. And my focus, I think, is as much on ways that it may be problematic to take up Indigenous law within Canadian constitutionalism. And so perhaps to sort of broaden even more the way in which you might think about your role vis-a-vis in teaching Canadian constitutionalism. And so the first point that I want to make is that how one approaches that question really turns on how one thinks about Indigenous law. And a great many folks, including a great many Indigenous peoples and Indigenous governments, think about that question really in terms of having an Indigenous authority be the source generating Indigenous law. And so we might think of that in two registers in terms of first, decolonizing the legal system. And so having an Indigenous actor, an individual, entire community, or maybe an institution be the source of authority. So for instance, appointment to a Supreme Court bench or governance positions within law societies or faculty appointments, largely, but perhaps not exclusively, within the framework of EDI. And then a little bit bigger, decolonizing Indigenous settler relationships more broadly. So the question of self-determination, and maybe more closely connected to the teaching of constitutional law in Canada, opening up questions like Aboriginal and treaty rights and negotiations and sort of larger scale projects that fit within the ambit of self-determination. And if, thinking in Indigenous law in this way of the sort of having an Indigenous actor of some sort in the source of authority generating it, certainly challenging in practice to realize some of these projects, but I suspect not so much to teach. I think that they rely largely on materials and knowledge that's widely publicly accessible, and that you probably don't need someone like Darcy or Darlene or Jeff or myself to help with that project, although I'd be interested to hear from folks afterwards. But as anyone who has spent time with Indigenous people in Indigenous community will know, the views just described very briefly isn't shared by a great many Indigenous folks today. And for many, their interests and aspirations, and critically, their legal and political claims, can't be accommodated simply by placing an Indigenous source of authority in that position. And I'm hoping that the Leroy Little Bear piece that I offered might help to explain why. So, you've all read it, I assume, and the device is fairly straightforward. He's inverting the anthropological gaze, subjecting Canadian law, in particular criminal process, to scientific and detached descriptions, and so a voice of objectivity. And as I read it, he proceeds with sort of three core features, and I think these are important. And so the first, is just this idea, I think common to probably all of us, the idea that law is storied, right? That it comes from somewhere and that matters. And so he gives three levels to that story. He talks about law itself, and then legal institutions, and then creation stories, or as he puts it, and I'll quote here, the beliefs and mythological premises upon which that institution is based. And then he gives another formulation a couple of pages later, the philosophical premises that are basic to Naidanak culture, premises that the society uses to relate to the world. So that first idea of there are these sort of three components, right, that one needs to understand in order to understand, and this is a key point, not just Indigenous law, but all law. But beyond that, right, he makes the second point that they're contingent on one another. And so you will only be able to make sense of law in a particular sense, or in a particular conception, given a certain kind of legal institution and its actors and its processes. Otherwise, your expectations might not be met and the law might look silly. And likewise, you'll have a certain kind of legal institution based on the kind of underlying story you tell about human communities and normativity. So the second point is really one of the contingency of how the three aspects line up together. And then the third piece is sort of the, I take it to be, his sort of central point, is how parochial and even ridiculous each of the three aspects might appear to us. And so, he lays it on heavy, using the language of ceremony and ritual thickly throughout to establish the point. And so he pokes at the conception of law as rules and how, to his mind, how overly articulated they are. And then in terms of institutions, he pokes at the role of the registrar and the institution of oath making, and even the adversarial process writ large. And then creation stories, right? He takes he's fairly scathing about his view of a sort of contractarian story of community and its implications for normativity. But, the central point of all of this, and sort of the insight that I'm hoping you might grab, they look ridiculous, each aspect, when measured against the metric of one's own legality, right? One's own. And so for those of us who have a common law training will certainly appreciate that there are very clear and long-running rationales for thinking about law as rules, and most of us also want to add principles and standards, and the role of the registrar, et cetera. But the point for Little Bear, right, is to show that measured against his Blackfoot legality, Canadian law looks just as silly as is just as shot through with culture. So the sort of central contribution that I'm offering up is to try and instill that insight in your students, to not take the cultural, the underlying cultural structures of the common law or civil law traditions in respect of constitutionalism in Canada for granted, to disclose it, right? And then to show how those philosophical starting points shape our Constitution and how they render a particular kind of institution and so a particular kind of law. So that's a huge piece, but then also that has real implications for how Canadian constitutionalism might interact with Indigenous law. And so I want to just pause it there and then continue the conversation with Jeff and others after.
Thank you, Aaron. Jeffrey?
Tansei and me, hello everybody. I would echo what everybody had to say too about all of you being here on a Friday on Zoom after probably a week of classes on Zoom, which is our new live. So thank you for doing that, and for David for organizing all of this for us. So Aaron and I had a good conversation about these things, and thank you to Aaron for all of the points you've just developed. I should also say to you, because I want to, that I'm coming to you from Williams Treaty territory today. So I'm in Barrie, just north of the law school. And And that's another piece that I've been trying to introduce into the classrooms when we're all over, is rather than just scripting land acknowledgements, getting students to be thinking about the spaces that they're in. And often I'll just be silent for a minute and ask them to reflect on what the land has given them yesterday and what they hope for the land to support them and give them today. So maybe some point during the day today, you might embark on that too. On the subject matter, both, you might have noticed from the readings that both Erin and I chose something different from Leroy Little Bear. And I also suggested something from Val Napoleon, and I want to pull out one of Erin's points around legal orders. And in Napoleon's piece that she writes about, and I use it in the very first, I try to use it in the first weeks of my classes to explain to students, whether they're first year or upper year, there's a difference that's quite fundamental between a legal order and a legal system. And we tend to just jump into talking about the legal system with students almost immediately. And in particular, in relation to Indigenous peoples and Indigenous legal orders, we think or lean into placing Indigenous legal orders in the context or conversation with common law systems. And so if we think of the orders as Napoleon describes them as sort of the big macro ideas or the principles that we believe in or values, and then the systems as the institutions by which we deliver and interpret those orders, those are different purposes. So trying to draw Indigenous legal orders into a decision or reasoning from a common law system is placing two things that shouldn't be placed together necessarily. If we want to talk about the origins of common law and the origins of Indigenous legal orders, that's something different. But there are also Indigenous legal systems. So for example, this past week in Constitutional, we've learned about Anishinaabe governance and lawmaking through totems as a system that delivers the order, the bigger thinking. So I also said to maybe think about reading Leroy Little Bear's Jagged Worldviews Colliding, because I start too with worldviews with students in Constitutional to just sort of decenter a little bit the idea about what they think law is. And that's among the first questions I will ask them. So what's law? You've all applied. It didn't happen by accident. You didn't just show up here because you took a left turn on campus pathway. You had to really think through and do the work to get into law school. So you must have had or hold some idea of what law is. What is it? And we'll talk about that. And from their responses, I try to engage in conversation with them. And then once we have a sense about what we think law is, I then introduce to say, well, let's now talk about a structured colonialism that we find in common law. Often to stairs, now on Zoom, just frozen stares. But I will then put myself right in it, and I encourage as many of you who can to do the same. So I usually stand in front of them and say things like, so good morning, I am a Cree man in Anishinaabe territory teaching you Canadian constitutional law in English. See the number of ways that I might be entangled in the colonial project right now while I'm with you. So let's have a discussion about you now and how you might be positioning yourself inside of what's going on. Some of them right away have things to say about the conflicts that they're wrestling with. Others, for the first time, have never had to articulate this. And so it's a moment to begin articulating that. Because as we sort of train in a legal mind, our job is words. And so if we can't figure out how to use our words, especially about the words that cause internal conflict, then we're not really gonna get through the best forms of advocacy, is what I try to tell the students. So I would recommend just picking up on Aaron's piece and his thoughts about Little Bear's work. Also think about including Napoleon and talking about orders and systems. Also, in terms of creation stories, I actually talk about those as a source of law in the first few weeks. And one of the things that I think is really important to draw out is that every single time I've heard the creation stories for both my dad's people, Cree people, and Anishinaabe people, because I'm in the territory, the carriers of those stories, or the tellers of those stories, they are consistently clear up front before they begin. All creation stories are true. And when we start from that premise, the next statement that's also reflected throughout is not only are all creation stories true, but it's not our job to figure out the differences, nor is it our responsibility to resolve the conflicts. All creation stories are true. And so when we begin with that premise, we're not coming along trying to tell everybody else why they're wrong, but recognizing that maybe there's differences and we just live with them. Other people's origins and the stories they tell themselves of how they came to be belongs to them. And making a decision, and we practice this in common law a lot, to tell others who they actually are and the rules and prescriptions by which we'll let them exist, is deeply problematic. And when you're one of the Indigenous students sitting in that classroom, this is why we don't have as many or enough Indigenous people in law. And constitutional is vital, right? Because it goes for, at least for us, through the whole year. So we have folks for both terms. And so I thought I'd just spend a few minutes with you talking about some of the big stuff. One of the other things I do in the first class is I hand out recipe cards to students and just say, write one question down that you want to know about Indigenous people, but you think you're too embarrassed to ask, even if you think it's racist. I need you to write it down. And then I collect them and keep them anonymized. And then week to week, I spend maybe 10 minutes at the class just randomly going through and trying to answer them. And I tell them, I'll know some, I won't know some. I'm going to try to figure out the answers for the ones that I don't know. And it's a practice every week in how to learn to articulate our conflicts or the problems. And if we can't also openly have discussions in a class with law students in constitutional about their bigger problems, I actually don't know who I'm teaching to. So it also gives me some insight from a pedagogical perspective into the minds of who am I talking to? So for example, one year, 3 times in the same class set, I got a question about why is it not okay to dress up like Pocahontas for Halloween? So we talked about that, but that also tells me that it was reflective 3 times where the class might be at. And then other years, I haven't gotten that question at all, but instead they zero in on, if I don't have a treaty from where I'm from, then what am I supposed, like the much more engaged or a different sort of question. So I start that and then I keep that conversation going throughout the course. So I start with worldview, as Aaron was talking about, including the creation stories. I don't tell them, but I do talk a bit about the context of what it means to respect other people's ways and stories. And then the other way that I do that is usually I put up on screen a visual of a scientific theory, an astronomic theory called parallax theory. And what that tells us from science is that the way that you see an object depends on where you stand. And determining your own position in distance or relation to another object is about your own physical presence or position. So for example, the image I use is like a gold star. And I say, so folks in the northeast corner, if you're looking at the gold star and there's a red background behind it, you're gonna see gold and red. If you're looking from a different angle, you might see gold and a blue background. And then we talk about that in the class to say, so if half of us are all, if we're all at the same intersection, half of us see at the northwest corner a blue car hit a red car, and in the southeast corner, the other half of us see the opposite. We're all going to find ourselves in court. And in an adversarial system, decisions need to be made about an objective truth. And so half of us are going to be found to be not as reliable or trustworthy as the other half when the judge makes a decision. So how does it make you feel to know that even though you've told the truth, you may still find yourself not being believed in relation to others? But what if truth is actually perspective-based and science tells us it depends on where you see it? The other piece about parallax theory is that, when humans have two eyes, we have a crossed field of vision, and it's actually parallax that gives us the depth perception. And so I talk about that in relation to common law and indigenous legal orders to say, in order to understand common law better, to be reflective in the ways that Aaron was describing, sometimes we actually need to see and understand something else, which might be, in this instance, indigenous legal orders, because it provides us with a depth perspective that we don't otherwise get. So those were a few things I wanted to just talk to you about drawing some of the principles that Aaron's raised from Little Bear's piece into how I translate those into the classroom. And on the land acknowledgements and the reflective piece and the Darcy stuff, which was so beautiful at the opening too, because we're closed as a law school, I've actually introduced Instagram this year. Thanks, because I have in part teenagers in my house who manage my Instagram for me. So I've done that with the classes because I wanted the students to figure out the visuals of law from the land that they're on, wherever they happen to be. And wow, it's a closed account just for our class only, but the images and the captions and the commentaries and the conversations they're having are these amazingly high level conversations with each other about relationships as to law, but also to each other as we're trying to kind of build that class, ethic of caring for each other. So that's one of the ways that I've been also trying to work on the what is law question that Aaron started us out with. So I'll hand it back to you, Darlene and Aaron.
Thank you, Jeff. I notice we have one question up already, so I'll call on Anver Eamon.
Thank you. Thanks, Darlene. Actually, it's nice to see you all, especially to Darlene. It's nice to see you. I just had a question. Well, first of all, I apologize. My video is not on. We are having a bandwidth issue here at my house, so just too many people online. I was wondering if in the panel discussion that we've had, and especially thinking with Aaron's comments about almost the inappropriateness of thinking about Indigenous law in the constitutional context, I wonder if the problem here was we're using constitutional law as our framework. What would happen if we changed the frame to conflicts of law or private international law? Would that change the way in which we would have this conversation? And I raise this only because also I noticed that a lot of North American schools don't actually teach conflicts of law as robustly or as regularly. So what is the onus, for instance, upon me as someone who floats in the first and second year and third year curriculum, really to think with Indigenous law, but through the lens of conflicts of law, not in fact constitutional law?
I'm happy to just jump in first. Well, so it's a terrific question, Amber, and I think for me, I might have some nervousness about it. I wonder if sort of the doctrinal framing around conflict of laws, if it allows for a deep enough comparison, can it actually push down to the sort of worldview level that that Jeff and I are talking about, or does it sort of make assumptions at that point, which then get carried into the framing of how we might speak across legal difference? So I guess I'm more comfortable trying to explode the notion of constitutionalism and sort of taking a step back from constitutional law to thinking about the actual structure of constitutionalism and how, depending on what kind of creation story we start with, we could render constitutionalism in a very different way, which will then, so for me, this is the missing step in Little Bear. I think between creation stories and institutions, mediating between them is constitutionalism. And this is sort of a, getting to be an aside, but I think that the structure of Indigenous constitutionalism here on Turtle Island is actually different in kind. And so that's sort of my worry. It's not just different, it's different in kind. And that would be my worry with the sort of conflict of laws kind of framing, although I think it makes a lot of sense to think in that way. And sort of, trying to take seriously the fact of the difference we're talking about.
Yeah, I would agree. I appreciate the point, Amber, and I think it's a really vital question. And more of that would be good, though I would say maybe at upper year, because part of what I find happens, so at Windsor, we introduced, when I was there, Indigenous Legal Orders mandatory course in the first year. Osgood, it's upper and slightly varied version. And I'm now in the second year of teaching the upper year version, and it's really different. So I'm just trying to pick out Erin's piece too. In first years, I had to get a little snappy at one point because about 5 weeks in, students in Indigenous legal orders would start saying things like, oh, yeah, so this is like in contracts where, and this is like in constitutional where, and start reframing things where they're working to resolve a conflict that they have, as opposed to just living with the dissonance and allowing Indigenous legal orders to be that, and allowing common law to be what it is. And to the point of where I got snappy, what I said was, you all need to stop this now. You've had 5 weeks of law school. You're talking about Indigenous legal orders as though you can compare it to contracts because you've got the exact same 5 weeks of contracts law. What makes you think you are a better expert in contracts that you could do that comparative work? You're not qualified yet. So how about you just learn to live with the differences and the discomfort with not knowing, rather than keep trying to solve the problems? Because the practice of trying to resolve that conflict is inconsistent with the premises or the principles of origin stories, creation stories that I've already told you about. So here's a way in which you're now engaging in this hierarchy of law, because when we're confronted with conflict, we want to sort that out. And so I think it's a great way to teach more of conflict of laws and how to do it well and responsibly. I don't know if it comes maybe in upper year though, which is probably not quite the question you were asking.
No, that's perfect. Thank you very much. Thank you both so much.
Thank you, Anver. We have a question from Nicole O'Byrne.
Hi, everyone. It's so great to see so many of my former teachers on here. I'm a little intimidated. I still feel like I'm pretty new, but I've been teaching at University of New Brunswick Faculty of Law since 2009. And I just, what Erin said about, this might be hard to put into practice, Indigenous legal orders, but it might be easy to teach. I don't know if it's easy, but I certainly love it. And my job is to introduce mostly non-Indigenous students to this whole really exciting area. Like I was introduced by Sakej Henderson and Norman Zlotkin, who it's so fun to see here today, because it really did open my mind to all these different possibilities. So I try to show that world opening to my students. So just a couple of comments. When I teach federalism in first year, I certainly start with the Royal Proclamation of the Treaty of Niagara. And if you can get the first year started thinking that that's normal, right? Then when you get them in upper year, your starting point is so much further ahead. So what I do in my upper year elective is it's a course on Indigenous, non-Indigenous relations with the whole idea that we're all treaty people. So even when I have a class that's primarily non-Indigenous folks, to say, well, this all matters because it's not just Indigenous issues. And then with respect to getting Indigenous content into the class, well, John Burroughs, I can see you here. Keep making videos, because I basically hit play and then I bring in Val Napoleon, or I bring in Sakej, or there's so many materials online, or people that are actually at the barricades being interviewed by people. Like, there's just so many materials that I've got. And I mean, from Idle No More on Twitter and whatnot, First Nations, Métis communities have really taken to the tech, right? So as a teacher, I just need to really plug into that. I mean, tonight, or tomorrow night, I guess it is, a tribe called Reds having a dance party on Facebook, and I'm taking my class, right? And then we're going to talk about that on Monday morning. And Maurice Sinclair is giving a lecture at Robson Hall on Monday. We're all going to that. So I guess there are some upsides to COVID. I'm trying to look at it in that vein. But anyway, Aaron, thank you so much for your presentation. And Jeffrey, keep writing those great articles, because I learned so much from you. Your material is wonderful.
Thank you.
Thank you, Nicole.
Can I just also say, Darlene, on that, one of the other exercises I build into the syllabus for the students is when I put on scholarship, Indigenous or not, I get the students every week to actually do a 1-minute bio of the scholar that we've read so that everyone in the class can hear about them. And I find that it helps them develop who is behind the writing and the reasons why, to give them some context. And they do it as opposed to me, so it comes through their words, not mine. This last week we did Wampum at Niagara, so obviously the bio on John Burroughs was really short. The only addition I had made to the students who had presented on John's bio was to say, the only other thing you guys missed was that John Burroughs is the founding member of the Write a Book a Month Club. So that's why there's so much from him.
Ed saw a question from Scott Franks, but now his hand is down. I'm wondering, did he want to ask a question?
Sorry, I wasn't quite sure. I think so. Hi everyone. I was kind of looking to see if I could maybe get some comments from either Aaron or Jeff about what I'm working on in integrating Nihao traditions in my first year tort law. Is that an appropriate space for me to ask questions and get thoughts on that in this context? Charlie?
I think so. We'll see what Aaron and Jeff think.
Sorry, I heard maybe 2/3 or 3/4 of it came across clearly. Could you try one more time, Scott?
Sure. So I'm teaching a first year torts class, and what I've done is I'm starting to integrate Sylvia McAdams' book Nationhood Interrupted, which covers Nihao legal theory as she's interpreted it in Treaty 6 territory. And so it's more familiar to me to work with that because that's the area that I'm from as well. So I've had the students read that, and then my goal is for them to interrogate the assumptions around the common law of torts about things about relationships to each other, to property, the idea of property and land, like intentional trespass kind of torts. That kind of use, I'm not teaching the Indigenous laws for students to be able to like, you know, and I mean this in this kind of this pejorative way, manipulate Indigenous law. I'm not teaching it for the sake that they can go and use it or apply it, but rather for them to be thinking about the common law. I'm wondering, there was a comment that you had, Jeff had made about deepening an understanding of Canadian law's own worldview. And I'm wondering if what I'm doing might fit into that. And also the second part of the course then uses that to understand the class actions around Indian residential school claims. So I'm wondering if there's any kind of flags that come up for you as I'm describing this in terms of some of the concerns that you've raised, Aaron, in your work about the use of Indigenous legal orders and what we've been discussing. Thank you.
Jeff or Aaron, do you have anything responsive?
I do, but I'm happy to let Jeff go first this time if he wants to jump in.
Oh, no, that's okay. I feel like I've done a lot of talking.
Well, thank you, Scott, and also congratulations on your appointment. So I feel like I'm hearing sort of two distinct aspects that you're sort of drawing into relationship, but that sort of first piece about sort of worldview context beneath, but then I feel like that's not your emphasis. You're wanting to focus, that's part of your setup, hey? You're wanting to focus more on the question of use in teaching. Is that, and so you have, is it a concern about a possible misstep? Is that the gist of it?
I think, yeah, that's the big one, is that how can I put up enough of those flags for students to see my intent in use so that unintended misuse doesn't happen. I just feel like I don't have, and I have to know that students have their own agency about how they receive material, and I can't always control that, but I'm wondering about that, the risk of misuse.
Yeah. Well, maybe a few thoughts. So in my, in my own work, I haven't done this today. I've had a bit of a different focus, but when I'm teaching, I take very seriously the point that Darcy and Jeff have made about situating myself in respect of the knowledge I carry and where it comes from, and the fact that it's relational, right, to people and to territory, and so I guess that does part of the work by sort of establishing a baseline norm, right? That this is, I'm sort of modeling it for them in terms of Indigenous pedagogy. And so they should already be tweaking, right? Like they should be adverting to the need for sensitivity around the issue. And then, Jeff's point about all creation stories being true, there's I would expand that even further and say, in the words of Nancy Jones, Anishinaabe Kwe elder from one community east of mine, just a 20-minute drive. She says all teachings are correct. And there's a wonderful oration that she's allowed to be transcribed about that. And so, that sort of just need for respect. And then, we've been invoking, it's au courant to invoke John in this dialogue, apparently. So I'll continue in that vein. But his teachings around humility resonate very, very strongly with what I've learned in Treaty 3, and that it's not about making oneself small, but about occupying the right amount of space. And if we think of terms of, of our own sort of internal makeup as a constellation of gifts that we've been given to carry, it's not honoring them to not share those gifts in a moment when they're called upon. And so in one respect, I think that's what Sylvia's done with her fantastic book, right? She's put it out there and she's taken some risk in so doing, and she's a very smart woman, she knows that. But also, you have certain gifts as a scholar that have brought you to this point, right? You didn't place yourself here. You've come here for a set of complex reasons, not all of your own design. And, if you have that feeling to work with a particular text and you're careful, in Anishinaabe legal principle, about going carefully and, privileging sort of as modalities, listening and watching over speaking, then you kind of have to have faith that you've put enough in place that you can engage in a respectful way, and that honoring your own gifts, that's exactly what you're supposed to do. So that, this is a way of saying the point that is sort of my most foundational point, that sort of anytime we're talking about Indigenous law, the how should be privileged over the what. And sort of if you're, it's a teaching I got very early on in my journey. It's just been invaluable. And so if you're doing all of the things in the right way and you're carrying yourself in the right way, you've probably discharged your responsibility. And so the test of your responsibility is like, have you done the work going into that moment, right? That's the piece. And then the actual substance of what you share in that moment, of course, matters, but actually not as much as sort of all of the preparatory work that's allowed you to be there in a good way.
Yeah. Those were beautiful words, Erin, and thank you, Scott, for the question so that Erin could say those thoughts to you. I won't add anything except a small little piece, which is to say, on Sylvia's book, the one you're talking about, the Revitalizing Hiola Nationhood, you should know, if you don't already, that book Sylvia took into ceremony with her when it was still the words on paper. And so the work being done by that book also has been sourced in ceremony. So the words that were put out, as Erin's described, she knows what she's doing, the words that were put out after the words themselves had gone through ceremony. So if you're having a strong reaction to that piece, it might be something for you to know in the background that those words have also done their work before they arrived on your syllabus.
I want to add one more piece too, actually, because I suspect it's
Me too now. I want to add another one.
I suspect it's a tension many in this circle today are carrying. So, you know, I've got many colleagues who are not Indigenous, and like many of you today, you know, wondering about the ethics of bringing this in what ways can I do that? I'm terrified of being called out. And, you know, where I'm from in Treaty 3, everything is about the training and about doing it in a good way. And my grandmother brings Catholicism into her Anishinaabe worldview, and very clear, you know, Anishinaabe is the worldview. It's what's doing the structuring, but she brings the substance of Catholicism in. Almost all of the elders that I would ask, what's this, you know, what is Anishinaabe and Akonigewin? What is our law? In Treaty 3 anyways, almost every time they want to start with the big drum. That's what they point me to. And that actually came to us in the late 1800s from Tailfeather women from the Dakota, right? It's not an Anishinaabe thing, and they will want to place it at the center of our law. You know, we can tie this all back into where Jeff and I started. If you follow law all the way down, not just one step to the institutions that have authorized it, but to the form of I should say the structure of constitutionalism, and then the creation stories below that. If you take it all the way down, then it actually can be fine to sort of welcome the other, so to speak. And that goes into the substance of the law, but I think it also goes into teaching it. So one of my colleagues who's part of this dialogue, you know, Kirsten Anker, I am an ardent supporter of her teaching one of the first year mandatory Indigenous law sections at McGill, because we spoke and I know her, and I know the training she's done and just how much heart she's put into it. And so I think that's a critical piece too, you know, of the question you're asking, Scott, about sort of the space we can occupy vis-a-vis Indigenous law. It's not for just anyone to do it, and it's hard work and it's a big commitment, but I do think it's work that in certain respects, others can take up. I'm careful to say in certain respects, right? When we get into ceremony, like this could be a much larger conversation, but I wanted to say just that much.
Thank you, Erin. This could all be a much longer conversation, but sadly our time is up. I noticed there were a few hands up. I'm sorry that we didn't get to your question. There's also a question from Jamie LaValle that's in the chat. If Erin or Jeff have a chance to look at it, maybe you can reply directly to Jamie. But I want to thank you for your amazing contributions to this conversation, and I think the themes that you've raised this morning it's morning in Vancouver, sorry, this afternoon will be food for thought for the balance of the workshop. So thank you very much. And we're now going to take a break until 10:30. Sorry, I'm again on Vancouver time. We'll take a break until 1:30 Eastern Standard Time. Thank you.
Darlene, thank you very much. You hosted that wonderfully well. And thank you to Erin and Jeff. That was wonderful. And also to Darcy. I'll send him a note later. But I wanted to tell everybody that we've got this 15-minute break. Stretch your legs, feed your kids, do whatever it is you need to do. I'm going to let the Zoom conversation continue. So they'll stop the recording right now. So if folks want to continue chatting, I believe you'll be able to continue to do so until we start up again at 1:30, again, if Jeff or Aaron are up for it. So thanks again to everyone and to you, Darlene.
Thank you.
Thank you.